right, we have Mr. Matson back with his audio connected now. When we were previously on the record, Mr. Matson dropped out of the Zoom session. That I'm not entirely sure exactly what time that happened. And so we discontinued the sentencing hearing at that time. Mr. Matson, I believe, logged back in sometime around 9:35 when I was conducting another hearing. And that was when I noticed someone in the waiting room that was labeled Robert's iPhone, which is what Mr. Matson's iPhone is labeled here this morning. I did bring that device into the Zoom session. When I noticed it, the camera was off, the audio was not connected. I did leave that there for a few minutes and then placed him back in the waiting room because the audio was not connected, and continued on with my other hearing. I will say that I believe he remained in the Zoom waiting room for 20 or 30 minutes and then disappeared from the waiting room. So I do acknowledge it appears that Mr. Matson tried to log back in to continue the sentencing hearing. We weren't able to make that happen, so I continued on with my other hearing, but we have everyone back with us now. Mr. Matson, we are in a court proceeding right now, and so I'm going to ask you not to eat anything and to remove your hood, please.
Sure.
All right, I'm going to ask you to remove your hood also, Mr. Matson. Thank you. So we had been through the sentencing procedure. I had given Mr. Matson an opportunity at allocution and was starting to announce the sentence. And so I will continue with where we left off. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the report and recommendation of the probation department, as well as what's been said on the record here this morning. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, vindication before the law, and the protection of society. Mr. Matson pled guilty to one count of controlled substance, attempted possession of cocaine, heroin, or another narcotic of less than 25 grams, pursuant to a plea agreement which dismissed one count of possession of cocaine, heroin, or another narcotic, dismissed one count of driving the license suspended, and one count of alcohol open container. I believe, am I correct, Mr. Daly, there was there a Killebrew agreement in this case to no upfront jail?
I believe there was a Killebrew in this agreement, Your Honor.
I'm sorry, Mr. Daly, was that a yes or a no?
No.
Okay. So the agreement was to one count of attempted possession of a controlled substance, dismissal of the remaining charges, and that was apparently incorrect. There was no sentencing agreement in this case. This is Mr. Matson's first felony conviction. He does have 4 prior misdemeanors. Those are all from 2015 or earlier. He has two 2015 cases and a 2002 and a 2001. And so the recommendation in this case from the probation officer is for a period of 1 year probation. And I think that, well, it also, I should say, includes restrictions on alcoholic beverages and substance use. And I think that those provisions of terms of probation are appropriate given Mr. Matson's Compass Needs Assessment scores. He did rate as highly probable in the categories of substance abuse, family criminality, residential instability, and social environment. He does have a substance abuse history of cocaine, fentanyl, painkillers since 2005. I think that it is appropriate to try to get Mr. Matson some help for his substance abuse problems. The concern I have in this case is that is whether or not Mr. Matson is going to be willing to comply with the terms of his probation. He has, in numerous court hearings in this case, made a number of what he believes are constitutional and jurisdictional arguments that have absolutely no legal merit whatsoever. And he continued to challenge the court's jurisdiction here this morning. I understand that that may be an honest belief that Mr. Matson has. And I don't know where it comes from, but I will say Mr. Matson would be far better off taking legal advice from Mr. Daly than from wherever it is that you're getting it to make you believe these arguments, because as I've ruled repeatedly, there's just no merit to them. They're not rational or coherent arguments under the law. And the concern that that raises with me is that Mr. Matson, if he does not believe this court has jurisdiction, why then would he follow the terms of his probation? And so if that's the question, then the question I have to ask myself is why would I put him on probation if there doesn't seem to be any indication that he would follow the terms of the probation? The other side of that coin is that I think a lot of this stems from Mr. Matson's substance abuse issues, and the better way to get him help for his substance abuse issues is to put him on probation and get him into some kind of services to help him deal with that. So ultimately, Mr. Matson, I'm going to give you a chance at probation, and I hope that you are willing to comply with the requirements that are outlined in terms of your probation, which I'll read to you word for word in a moment so that you're aware of them. If you choose not to comply for the reasons you've stated or any other reasons, you can rest assured you're going to find yourself in violation of the terms of your probation. And then I am going to be imposing other penalties, meaning for you jail time. And I'll just tell you now, it'll be a short leash, because if we continue down this road, I'm already suspect of your ability to comply. So any violations are just going to confirm that for me, and you're going to find that I'm going to lose my willingness to give you a chance. So it will be the sentence of the court that you serve a period of probation for 1 year, that you serve 29 days in the Lenawee County Jail with credit for 29 days served. You must not use or possess alcoholic beverages or other intoxicants. You must not enter bars or other places where the primary purpose is to serve alcoholic beverages for drinking on site, unless the field agent has first given you written permission for your employment at a specific location. You must comply with the requirements of drug and alcohol testing as directed by the field agent. You must not attempt to submit any fraudulent or adulterated samples for testing. You must not hinder, obstruct, tamper, or otherwise interfere with the testing procedures. And you must present proper identification at the time of testing. You must pay the cost of your substance abuse testing. You must not be in possession. You must not use or possess any controlled substances or drug paraphernalia unless prescribed to you by a licensed physician. And you must not be with anyone that you know to possess those items. You must complete an outpatient or residential substance abuse treatment when you are referred by the field agent. You must complete a substance abuse assessment when you are referred by the field agent. You must pay a $30 per month supervision fee, so long as there's no electronic monitoring. If electronic monitoring becomes necessary, that fee increases to $60 per month. You must also pay court costs of $750, an attorney fee of $450, a crime victims' rights fee of $130, and $68 state costs. You do, Mr. Matson, have the ability to request an appeal of your sentence. We're going to send to you 3 copies of a notice of right to appellate review and request for appointment of attorney form. We ask that you sign 1 copy of that form and mail it back to the court. That indicates that you received your copies of the form. If you want to appeal your sentence, you need to fill out the other copies of the forms and mail those to the address listed in those forms within 42 days. Do you understand that, Mr. Matson?
Yes, I do.
All right. With that, then, we can conclude the hearing. Thank you all for your time and logging back in, and you can all go ahead and log out.
Your Honor.
Judge.
Your Honor.
I'm sorry. Yeah, Mr. Stevenson. So, Mr. Matson, Mr. Stevenson, I think needs to provide you with some information about when you should report and probably get some contact information from you. What I'm going to do is stop the YouTube stream so that we can do that.
Hey, Judge, I just had a couple questions, if I may, from you concerning what you just said.
All right. What's your question?
Well, if there's a crime victims fee, I'd like to know where the victim is, and also, Your Honor, you said something about the jurisdiction. If there's no problem with the jurisdiction, I mean, how come you couldn't tell me exactly which jurisdiction you're operating under? So I would have to object to what you said. I mean, it don't make no sense to me, Your Honor.
I told you that before, Mr. Matson. I'll tell you again. I'm operating under the jurisdiction of the Michigan Constitution that sets forth the fact that the state has various circuit courts. I'm the judge of one of those circuit courts. That one being where you were alleged to have committed this crime and where you pled guilty to this crime. As far as the crime victims' rights fee, that is assessed in every case where there is a guilty plea or verdict. That is done pursuant.
The sovereign citizen's mistake was relying on living man and other internet-sourced legal arguments. Courts operate under statutory and constitutional authority, and such pseudo-legal defenses hold no legitimacy. The judge neutralized each claim calmly but firmly, emphasizing adherence to the law and the necessity of following probation rules. This case demonstrates the stark difference between online legal myths and courtroom reality. Sovereign citizen arguments often fail because they misinterpret jurisdiction and constitutional principles. Observing this courtroom interaction teaches viewers the importance of credible legal counsel, the consequences of noncompliance, and how judges maintain order while protecting public safety. It's a clear lesson in why following actual law, not internet theories, is crucial for avoiding serious consequences.